Hello everyone, and welcome to week 3 of Poll 101, American Government. This week we're discussing civil liberties and selective incorporation. Today's video is going to be broken up into 3 parts, and here's part 1's agenda. First, we're going to discuss the difference between civil liberties and civil rights. This week's lecture is all about civil liberties. Next week's lecture is all about civil rights. We're going to discuss the origins of our civil liberties and where they come from. And we're going to spend most of the lecture talking about this process called selective incorporation. We're going to also discuss other constitutional concepts and pivotal court cases. So what are our civil liberties? Civil liberties are political freedoms that protect individuals from the abuses of the government. This is very different from what civil rights are. And I have this helpful graphic to help us understand and visualize the difference between the two. So civil liberties are protections from the government. Civil rights are protections by the government. So another way of thinking about this is that civil liberties are those kind of natural rights that we're entitled to, that the government cannot infringe upon. On the other hand, civil rights, like voting rights, are protections by the government. In the case of civil rights, it's the government's responsibility to make sure that these rights are protected. So I hope that this visual helps clarify the difference between the two. And what I want you to understand about our civil liberties is that those foundational liberties, they come from the Bill of Rights. And in order to kind of conceptualize this lecture, we need to return briefly to the Federalist and the Anti-Federalist debate that we touched upon a little bit last week. So according to the Federalists, right, they didn't really see much of a need for incorporating a Bill of Rights into the United States Constitution. Why? Well, they had 3 specific points. 1, most states already had a Bill of Rights in their own constitution, so they didn't think that a national Bill of Rights was necessary. Moreover, they didn't want to conflict with what state constitutions had written. Second, they were fearful of this enumeration trap, this idea that, okay, we can spend all this time writing out what our civil liberties are, but what if we forget something? What if we leave something off the list? What if something comes up 200 years from now that we can't even fathom? We don't want that to be perceived as not a right just because we didn't write it down. And then lastly, they argue that the Constitution itself was a Bill of Rights, and thus additional amendments were simply not necessary. On the other hand, the Anti-Federalists, like we talked about last week, refused to ratify the United States Constitution without some type of codified Bill of Rights. They believed that a constitution without such a Bill of Rights would create a government that was far too powerful and would be able to infringe upon the rights of the American people. Secondly, there was nothing in writing whatsoever to secure foundational individual liberties. Again, the Anti-Federalists said we must have something in writing if we're going to ratify this Constitution. And then lastly, the Anti-Federalists were of the firm opinion that a Bill of Rights would ensure federal government accountability, that this would serve as a legal mechanism whereby the federal government could not legally infringe upon the rights of the American people. And like we talked about last week, that's exactly what we ended up with. The Bill of Rights are the first 10 amendments that were added to the United States Constitution. We have them all listed here, right? So I would like you to know what each of the first 10 amendments are. First Amendment is freedom of speech and lots of other things, actually, but we generally refer to the First Amendment as the speech amendment, but there's 5 different rights just within the First Amendment that we're going to talk about today. The Second Amendment is the right to bear arms. The Third Amendment is protection against quartering troops, so the government can't force you to house troops in your home. The Fourth Amendment is about protections against unreasonable search and seizure. The Fifth Amendment is about due process under the law. The Sixth Amendment is about protections for your legal right to counsel. The Seventh Amendment protects your right to a trial by jury. The Eighth Amendment protects you against cruel and unusual punishment from the government. Ninth is kind of interesting. These are rights not enumerated. We're going to get to this one a little bit later in the lecture. Essentially what the Ninth Amendment means is that just because we didn't write it down doesn't mean that it should be construed as not a right. So the Federalists really wanted this Ninth Amendment included in the Constitution to account for that enumeration trap that they were worried about. And then lastly, we have the States' Rights Amendment. So essentially what that means is that anything that's not mentioned here already is a state's right. And in today's lecture, we're mainly just going to focus on Amendments 1, 4, 5, 6, 8, and 9. Your book mentions a ton of different court cases in Chapter 3, but I want you to just know that you're only going to be tested on the court cases that appear in this lecture because I don't want to inundate you with hundreds of court cases. I just want you to know what's discussed in this lecture. But let's talk about what the Constitution actually says with respect to these Bill of Rights. The Bill of Rights actually begins with the language that you see here. Congress shall make no law. And while that might not seem like much of a distinction at all, this leads us to actually one of my favorite games that we get to play in politics, which is called Find the Loophole. And the glaring loophole here being that there's no mention of what state governments can or cannot do. So technically, all of these civil liberties that we just discussed in the Bill of Rights only apply to laws written by the United States Congress. And technically, there's nothing in the United States Constitution that bars states from infringing upon these rights. In fact, it wouldn't be until 1868 that there would even be a legal framework for applying the Bill of Rights directly to state governments. This would be made possible through the passage of the Civil War amendments. And as a refresher, what are those, right? That's the 13th Amendment, which bans slavery, the 14th Amendment, which provides equal protection under the law, and the 15th Amendment that states that the right to vote shall not be denied on the basis of race. And in particular, it's the protection clause of the 14th Amendment that would ultimately extend the Bill of Rights to also apply to state governments. Specifically, this clause here. No state shall deprive any persons of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. And the point of today's lecture is to really detail the decades of legal battles in the Supreme Court that would ultimately extend our constitutional protections to the state level. This process is what we refer to as selective incorporation. It's the legal process by which the Bill of Rights were incorporated through the 14th Amendment and thus applied to the states. So let's go ahead and jump right in, starting with the First Amendment. And like I said earlier, there are actually 5 distinct liberties within the First Amendment. It's not just about speech. We have the Establishment Clause, which means that the government cannot establish or write laws that favor one particular religion over the other. There's the Free Exercise Clause, which means individuals are free to practice whatever religion they prefer. There's the freedom of speech. There's freedom of the press, and then there's freedom of assembly and petition, that the government cannot stop you from protesting, essentially. And your book goes into a lot of detail on each of these, but we're really just going to focus on the first 3 because even today, the Supreme Court continues to hear a lot of cases on these issues, and there have been some pretty important developments here that I want to discuss as well. And as we discuss today's lecture content, we're going to do something a little different today. We're going to play one of my favorite games that's called Is It Constitutional? And I actually do want to encourage you to keep score of how many questions you get right, because I really want to see your reactions to the cases and the discussion board and how many questions you got right, which cases surprised you. Oftentimes, a lot of students are really shocked to learn that some of the cases that we talk about and some of the laws that are discussed are completely constitutional. So get ready to record your answers, and let's begin. First, let's start with the Establishment Clause in the First Amendment of the Constitution, which prohibits the government from making any law respecting an establishment of religion. Consider the following questions. Is it constitutional for schools to mandate a morning prayer each morning? Is it constitutional for government buildings to erect religious displays? Is it constitutional for the local government to use tax dollars to fund religious schools? Now let's start with prayer in school. The seminal case I want to talk about is Engel versus Vitale in 1962. So in 1962, the state of New York approved a non-denominational prayer for educational morning procedures. If students didn't want to participate, they could be excused. And the prayer was pretty innocuous. It read as follows: Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. Amen. So what do you think about that? That doesn't sound too terribly bad, does it? Do you think that this was constitutional or not? Well, the answer is no. In a 6-1 decision, the Supreme Court deemed this unconstitutional. They argue that prayer is an inherently religious activity, and the prescription of such activity by a publicly funded school is a violation of the Establishment Clause, even though it was a completely non-denominational prayer, and that if students didn't want to participate, they were free to not do so. And the Supreme Court has ruled pretty consistently in such cases involving religious practices in public schools, such as Bible reading, moments of silence, public prayer, preceding sporting events, all kinds of things like that. But what's interesting is if you've been following the news lately, you might be familiar with this Louisiana law that recently passed that requires all public places of education to display the 10 commandments prominently in each classroom. In fact, Louisiana Governor Jeff Landry reportedly told a group of GOP state lawmakers and donors at a gala dinner in Tennessee that he can't wait to be sued. And he's really excited to take this case to the Supreme Court because, as we're going to talk about throughout this lecture, the court has really changed the dynamic and the culture of decisions that it makes in recent decades. The decisions have become significantly more supportive of religious freedom and expression. The decisions have become extremely more supportive of corporate interests. And as you can see in this image here, right, the idea is that this Louisiana's 10 Commandments law is essentially being served up as Supreme Court bait. And the idea is that now with a more conservative majority on the court, lawmakers are hopeful that if this case is heard before the Supreme Court, that it might overturn some of these earlier precedents we have that are very rigid on the Establishment Clause. So that's certainly something to keep an eye out for in the next few years. Let's move on. What about religious displays on government property? Do you think it is unconstitutional, for instance, a display of the 10 Commandments to be featured on the state capitol? And that seminal case is Van Orden versus Perry in 2005, and that's exactly what happened. Texas erected a monument of the 10 Commandments on the grounds of the state capitol building. And so what do we think here? Is that constitutional or is that unconstitutional? Well, according to the Supreme Court, this is perfectly constitutional. In a 5-4 decision, the court argued that simply having religious content or promoting a message consistent with a religious doctrine does not run afoul of the Establishment Clause. And lastly, what about using public tax dollars to fund religious schools? The seminal case here is Lemon v. Kurtzman in 1971, where Pennsylvania enacted legislation that would allow taxpayer dollars to reimburse church-affiliated schools to cover expenses like teacher salaries, textbooks, instructional materials, things of that nature. So do you think that this law violates the Establishment Clause? Well, the answer is tricky, especially considering that the public tax dollars were used to help subsidize instructional materials and teacher salaries. In order to answer this question, the court developed a 3-pronged test known as the Lemon test to help courts determine whether such laws violated the Establishment Clause or not. So the Supreme Court argued that aid to religious schools is constitutional when the following criteria are met. That 1, the aid is secular in purpose. 2, that the aid neither advances nor inhibits religion. And that 3, it does not excessively entangle government and religious affairs. And this last point here, it's incredibly vague. And how do we determine what constitutes an excessive entanglement of government and religion? And this wording is intentionally vague, and it's supposed to be confusing. And it's something that we see the courts do quite often, in fact, which is why these type of cases always seem to pop up in the court system every couple of years. Ultimately, the Supreme Court found that the Pennsylvania law did represent an excessive entanglement between government and religion. So in an 8-1 decision, the court argued that this law was unconstitutional under the Establishment Clause. So I've got the kind of answers put up here. So the X representing unconstitutional, the check mark representing constitutional. How did you do on the first round? And if you didn't do so hot, don't worry, because we've got 3 more rounds of this game to go. Let's consider the next series of questions which center on the Free Exercise Clause in the First Amendment. So the Free Exercise Clause reserves the right of American citizens to practice any religious belief and engage in religious rituals that they choose. And so let's consider the following questions. First, can local governments ban religious animal sacrifice? 2, can a state deny unemployment benefits to a worker when fired for using hallucinogenic drugs as part of a religious practice? And then finally, can religious-oriented for-profit companies deny health coverage of contraceptives to its employees on the basis of a religious objection? First, let's consider the question of whether or not cities have the constitutional authority to ban religious animal sacrifice. It's a wild question, I know. You probably didn't think that we were going to talk about this in today's lecture. This was the question in the case of the Church of Lukumi versus the city of Hialeah. So the Church of Lukumi is an Afro-Caribbean-based religion that practices Santeria, so that includes things like divination, animal sacrifice, and mediumship. And upset with these practices, the city of Hialeah, Florida, passes an ordinance banning animal sacrifice in the city limits. And so what do you think? Is this constitutional or not? Does this infringe upon the Church of Lukumi's members' ability to practice their religion or not? And so according to the Supreme Court, in a unanimous decision, the court ruled that the ordinance was unconstitutional as its singular purpose was to target a very specific religious institution, and it did not have a compelling government interest in doing so. And one of the key questions courts will consider when determining whether a law is constitutional or not is whether that law is narrowly tailored. In other words, if the law intended to apply to everyone equally, or is it the intent of the law is it aimed at targeting a specific group? And in this case, especially with the unanimous decision, it's clear that the city of Hialeah passed this ordinance with a narrow intent. It was meant to directly target and apply only to the Church of Lukumi, thus making it unconstitutional. Next, can a state deny unemployment benefits to a worker when fired for using hallucinogenic drugs as part of their religious practice? This was the question at hand in the seminal case Employment Division of Oregon versus Smith in 1990. So Smith was fired from his job at a private drug rehabilitation clinic, God of all places, for using hallucinogenic drugs, peyote, for religious purposes at his Native American church. And Smith was later denied unemployment benefits from the state because he was fired for misconduct. So does this denial of benefits, is this constitutional? And according to the Supreme Court, yes, it was perfectly constitutional. In a 6-3 decision, the court ruled that the Oregon Employment Division was justified in its denial of benefits because Smith's actions were non-compliant with valid pre-existing Oregon law. So how is this case any different from the one that we just discussed? Well, firstly, laws criminalizing the use of hallucinogenics is not narrowly tailored, and the government has a compelling interest in its regulation. Second, we need to consider the ripple effects of such exceptions. Scalia, writing for the majority opinion, argued that allowing such exceptions would, quote, open the prospect of constitutionally required exemptions from civic obligations of almost every conceivable kind, such as compulsory military service, payment of taxes, vaccination requirements, and child neglect laws. So the court wanted to be really careful about the precedent that it set in this case. And finally, Can religious-oriented for-profit companies deny health coverage of contraceptives, such as birth control, to its employees on the basis of a religious objection? And this was the question at the heart of the 2014 case Burwell versus Hobby Lobby. And for context, under the Affordable Care Act, employment-based health care coverage must provide certain types of preventative care, including contraceptives like birth control. Now, the Green family, who are the owners of Hobby Lobby, which is a Christian-oriented arts and crafts store, believe that this was a violation of their religious principles, as they consider birth control immoral and an impediment on the free exercise of their religious values. So, this one's complicated. Is it constitutional for the government to force a religious-oriented company to provide healthcare services that it finds personally and religiously objectionable, despite the healthcare needs and concerns of its employees? And in a shocking ruling, the Supreme Court said yes. In a 5-4 decision, the court agreed that this was a violation of the Free Exercise Clause and essentially extended the protections of the Bill of Rights to corporate entities. And I've got a quick stop and think for you to consider here regarding your reaction to this case, because generally when students learn about this case, they're very shocked to hear that the Supreme Court decided it the way that they did. Opponents of the ruling argue that this case sends the message that rights of corporate entities are more important than the rights of individuals. Moreover, what kind of precedent will this case set for future free exercise cases? And you may have heard of other cases like the Masterpiece Cake Shop case in 2017, where the Supreme Court determined that a law which compelled a cake maker to design a wedding cake for a same-sex couple did, in fact, violate the cake baker's right to free exercise. Or a very similar case from 2023, just last year, involving the same set of circumstances, but with a wedding website designer. Again, the Supreme Court argued that forcing these individuals to create content that violates their sincerely held religious beliefs is unconstitutional. So for the stop and think prompt, I'd like you to consider how we can simultaneously guarantee free exercise for the people while also protecting others against discrimination on the basis of religion. That's a tough question, but I'm just curious to hear what your ideas are in the discussion board. Just go ahead and pause the video, write down your response, and hit play when you're ready to proceed. All right, so far we've asked 6 different questions in our game. Is it constitutional? And here's the correct answers for the last 3 that we just went over. And this is where we're actually going to stop and wrap up part 1 of the video. So don't forget that we're going to continue our game into the next part. So keep track of your scores. And if you need a break, go ahead and pause, or stay tuned if you're ready to proceed with part 2. All right, for part 2, we are just talking about free speech. So for our agenda, we're going to talk about what are the limitations of free speech. We're going to talk about 4 different kinds. We're going to talk about political speech, symbolic speech, fighting words, and obscenity. And the main thing that I want you taking away from this entire lecture and all of its parts is that there are no absolutes when it comes to our rights. We are not entitled to an absolute right of freedom of speech. We are not entitled to an absolute right of freedom of religion or expression. There are limitations, and this lecture is all about defining those limitations. And in the discussion board, it's all about us as citizens of this democracy discussing whether or not we agree with the lines that we have drawn as a society and as a government of where these boundaries and limitations are. So let's go ahead and jump right in talking about the selective incorporation of free speech. And I actually want to start by discussing how we experienced a very brief and turbulent problematic history with respect to the rights of free political speech in our country. So in 1789, again, just a few years after we had ratified the United States Constitution, and we were trying this experiment all over again, in 1789, John Adams signs into law the Alien and Sedition Acts. And essentially what this did is, it made it more difficult for immigrants to become citizens. It allowed the president to imprison and deport non-citizens who were deemed dangerous, especially from nations deemed hostile towards U.S. interests. And lastly, it criminalized making statements that were critical of the United States government, which does not sound like laws that should exist in a free, fair democracy. And so by 1800, the U.S. had not set a very optimistic precedent for the protection of political speech or any speech critical of government activity. We were very quickly on a path towards authoritarianism. And what's interesting is that the Alien and Sedition Acts were actually never overturned or deemed unconstitutional by the United States Supreme Court, but once Jefferson had defeated Adams in the 1800 presidential race, he essentially just decided to not renew these acts, and then they kind of just went away forever. But let's get back to our game. Is it constitutional? We have 2 more rounds to go. So let's consider these next 3 questions. Is it constitutional? A federal law that prohibits individuals from criticizing the draft and encouraging others to disobey its orders. A state law that prohibits hate speech, which advocates for various illegal activities. And then lastly, a federal statute that prohibits individuals from spending unlimited amounts of money in American campaigns and elections. Let's consider this first question. Whether or not it's constitutional to have a federal law that prohibits individuals from criticizing the draft and encouraging others to disobey its orders. So during World War I, Charles Schneck distributed a bunch of leaflets declaring that the draft violated the 13th Amendment. In other words, it represented involuntary servitude, and that the public should disobey the draft peacefully. The United States government maintained that Schneck be charged with conspiracy to violate the Espionage Act and attempting to cause insubordination in the military and obstruct government war efforts. So was Schneck's rights to free speech violated here? And that answer is no. In a unanimous ruling, the Supreme Court argued that the Espionage Act did not violate Schneck's right to free speech, and that this was a justifiable exercise of power on behalf of the United States government. And here we get the establishment of the clear and present danger test that the courts use to determine whether or not speech is protected or not. So the core of the test being whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. And so yes, in this case, having an individual running around distributing pamphlets and leaflets that say, the government's evil, the draft is comparable to involuntary servitude and slavery, don't join the draft if you get drafted. Yes, Congress has a compelling interest in prohibiting that type of speech because consequences are pretty severe. Let's consider the second question. What about a state law that prohibits hate speech which advocates for various illegal activities? So here I want to talk about the Brandenburg versus Ohio case in 1969. Brandenburg, a leader of the Ku Klux Klan, made a speech at a Klan rally and was later convicted under an Ohio criminal syndicalism law. The law made it illegal to advocate for economic or political reform by means of crime, sabotage, violence, or unlawful methods of terrorism, as well as assembling with any society, group, or assemblage of persons formed to teach or advocate the doctrines of criminal syndicalism. So what did Brandenburg say in his speech? Brandenburg said that the KKK might have to seek revenge if the president, Congress, and the Supreme Court continued to suppress white Americans. Brandenburg also said he believed that blacks should be returned to Africa and Jews to Israel. So what do you think? Was Brandenburg's right to free speech violated by Ohio's syndicalism law or not? Well, in this case, the court argued yes, that the Ohio law did violate Brandenburg's First Amendment right to free speech. The court also established the Brandenburg test. that 1, speech may be prohibited if it is directed at inciting or producing imminent lawless actions, or 2, if the speech is likely to incite or produce such action. In the opinion of the court, nothing about Brandenburg's speech incited imminent lawless action. Rather, he was just promoting hate speech. And so what's important to recognize here is that to a degree, right, there are certain types of hate speech that are technically constitutionally protected as long as they don't incite imminent lawless action. And for our final question, what about a federal statute that prohibits individuals from spending unlimited amounts of money in American campaigns and elections? This was the question in Buckley versus Vallejo in 1976. And for a little bit of background, in the wake of the Watergate scandal, Congress attempted to root out corruption in political campaigns by restricting financial contributions to candidates in the Federal Elections Campaign Act, or the FECA. Among other things, the law set limits on the amount of money that an individual could contribute to a single campaign, and it required reporting of contributions above a certain threshold amount. The Federal Election Commission was also created to enforce this statute, and various politicians and unions challenged the constitutionality of this law, claiming that it was a violation of the First Amendment protections on freedom of expression, really making this idea that spending money is comparable to freedom of expression. So in a complicated ruling, the court upheld and struck down the following provisions of the FECA. So the court upheld limits on contributions to candidates. The court upheld the aggregate limit on an individual's total contributions to all candidates and committees in a particular calendar year. But the court struck down limits on expenditures by candidates, and the court also struck down limits on independent expenditures. These are expenditures by other groups or really wealthy individuals, as opposed to candidates and political parties. So the main thing that I want you to understand about Buckley versus Vallejo is that the court set the precedent that spending money is a form of expression protected by the First Amendment. And I would love to hear your ideas in the discussion board about whether you agree with the Supreme Court ruling or not, especially considering the distribution of wealth in this country and the inequality involved in the distribution of generational wealth and all kinds of things like that. Do you agree that we should treat spending money to that of being constitutionally protected, a constitutionally protected form of political expression or not? And so as a recap, we have our answers here, just so you can stay on track with the number of questions you're getting right and the number of questions you're getting wrong. And here I've just got a little summary slide of everything that we've talked about so far with respect to political speech and what the major tests are that came out of these cases and what the outcomes were. And now on to our final round of Is It Constitutional? These are our last questions, so let's focus. Is it constitutional for a public school policy that prohibits students from wearing armbands as a form of symbolic political protest? Is it constitutional to have a public school policy that prohibits students from displaying messages promoting the use of illegal drugs at school-sponsored events? And then lastly, is it constitutional to have a state law that bans movie theaters from showing films with obscene content? So Tinker versus Des Moines, 1969, and Morse v. Frederick, 2007, are our two symbolic expression cases. So let's talk about Tinker first. So in December 1965, a group of students in Des Moines held a meeting in the home of 16-year-old Christopher Eckhart to plan a public showing of their support for a truce in the Vietnam War. They decided to wear black armbands throughout the holiday season and to fast on December 16th and New Year's Eve. The principals of the Des Moines school learned of the plan and met on December 14th to create a policy that stated that any student wearing an armband would be asked to remove it, with refusal to do so resulting in a suspension. And so on December 16th, Mary Beth Tinker and Christopher Eckhart pictured here, wore their armbands to school and were sent home. And the following day, John Tinker did the same with the same result. The students did not return to school until after New Year's Day, the planned end of the protest. So through their parents, the students sued the school district for violating the students' right of expression and sought an injunction to prevent the school district from disciplining the students any further. Ultimately, the case went all the way to the Supreme Court, where the court delivered its 7-2 majority opinion that held that the armbands represented pure speech that is entirely separate from the actions or conduct of those participating in it. The court also held that the students did not lose their First Amendment rights to freedom of speech just because they stepped onto school property. So in short, yes, the Supreme Court agreed that this school policy that prohibited students from wearing armbands as a form of symbolic political protest was unconstitutional. Next, we have to talk about maybe my favorite court case of all time, Morse versus Frederick, 2007. So just for a little bit of background, on January 24th, 2002, students and staff at Juneau Douglas High School in Alaska were permitted to leave class to watch the Olympic torch pass by as part of the 2002 Winter Olympics. Frederick and his friends waited for the television cameras so they could unfurl a banner reading "Bong Hits for Jesus." Principal Deborah Morse took away the banner and suspended Frederick for 10 days. And she justified her actions by citing the school's policy against the display of material that promotes the use of illegal drugs. So the main question here, right, is does the First Amendment allow public schools to prohibit students from displaying messages promoting the use of illegal drugs at school-supervised events? And unfortunately, the Supreme Court, in a 5-4 ruling, voted that this was constitutional. That school officials can prohibit students from displaying messages that promote illegal drug use. And in particular, Chief Justice John Roberts, the majority opinion writer, held that although students do have some right to political speech even while at school, this right does not extend to pro-drug messages that may undermine the school's important mission to discourage drug use. And then finally, our obscenity case. We have to talk about Jacobellis versus Ohio in 1964. And this case is just wild, right? So there's this theater manager in Ohio that's charged and convicted of showing an obscene film. The movie he showed was a French film called Le Mans, or The Lovers, and just like the idea of thinking about how it compares to like the type of media that we see today. I mean, like this screenshot here is like about as obscene as the sex scene in the movie gets. But at the time, Ohio had a law that prevented, the dissemination of obscene materials like this. So when Jacobellis showed the film, he was arrested for violating that law. And of course, this case goes all the way to the Supreme Court, where they ultimately find that Jacobellis's First Amendment rights were in fact violated. However, the courts fiercely debated how to define what constituted obscene content. You may have heard this quote before. What I'm about to read is what Justice Potter Stewart had to say about this case. I shall not today attempt further to define the kinds of material I understand to be embraced with that shorthand description, and perhaps I could never succeed in intelligibly doing so, but I know it when I see it. And the motion picture involved in this case is not that. So when trying to define what is obscene and what is not obscene, I know it when I see it. It's really hard to put boundaries on, but I know it when I see it. So when it comes to determining what's obscene and what's not, we see that this speech doesn't have the same degree of protections as other types of speech, like political speech or symbolic speech, because our court systems have had a really hard time operationalizing or defining or creating criteria around what constitutes obscene content. All right, and here's the recap of our answers. That's it for our game show. Is it constitutional? We had a total of 12 questions, and I'm really just curious to hear how many you got right, or which of these cases really surprised you. But let's go ahead and start wrapping up part 2 of the lecture. The main thing to take away from this lecture is that There are certain types of speech that are much more protected than others, and freedom of speech is not an absolute, right? Political speech and symbolic speech are very well protected under the United States Constitution, whereas things like fighting words, defamation, and obscenity, these are far less protected, and they've generally faced a lot more ambiguity before the Supreme Court. And as we wrap up our lecture on freedom of speech, I just want to introduce us to our second stop and think. So is there speech that you think should be banned because it doesn't contribute at all to the democratic exchange of ideas? And how do we determine what speech should be protected because it does contribute to this exchange of ideas and what speech does not? So feel free to also consider the role that you think social media companies like Facebook or X or TikTok should have in regulating speech on their platforms. So go ahead and take a moment to pause, reflect on your responses to these prompts, and when you hit play, the final part of our video lecture will begin. All right, finally, we have come to part 3 of our lecture on civil liberties, where we're going to mainly be discussing the rights of the criminally accused and the right to privacy. I like this lecture a lot because it's essentially all about understanding what your rights are when you are accused of a crime. So we're going to talk about the rights of the criminally accused, particularly through Amendments 4, 5, 6, and 8. And then at the end of the lecture, we're going to talk about the significance of the 9th Amendment, which has generally been interpreted as a right to privacy, and how that in particular has changed quite a lot just over the last 2 years. So we're going to take these one by one, Amendments 4, 5, 6, and 8, over the next few slides. Let's start with the 4th Amendment, which reads that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure, and no warrant shall issue but upon probable cause. Okay, so essentially the 4th Amendment is all about you have the right against unreasonable search and seizure, which means that unless police or law enforcement have a warrant, you're protected from a search. And there's lots of cases here. You don't have to, the only case I really want you to know on this list is Mapp versus Ohio, which we're going to talk about in just a second. But I mean, here's just a few examples of cases that have come before the Supreme Court regarding these unreasonable search and seizures. So police may not search your residence without a warrant. They are not allowed to do that. Police cannot use canine narcotic dogs on your front porch without a warrant. Police cannot use GPS to monitor suspects without a warrant. And police cannot seize evidence on your cell phone during an arrest without a warrant. So this is all about knowing your rights. And let's talk about Mapp versus Ohio real quick, because this is the seminal court case that incorporated the 4th Amendment to apply to state governments. So here we have Dolly Mapp, who is a young woman involved in an illegal gambling ring in Cleveland, Ohio. And police get a tip that a suspect in their racketeering case is being harbored in Mapp's apartment. And so police enter Mapp's home without a warrant, seize unrelated items to the investigation, such as a pistol, gambling paraphernalia, pornography, and they arrest her. Now, what is critical here is the use of the exclusionary rule, which means that evidence that is obtained during an illegal search may not be used in court. Such was the case in Mapp versus Ohio, and in 1961, Dolly Mapp went free. Next, let's talk about the 5th Amendment. There's a lot of different rights in the 5th Amendment. There's a right to a grand jury, a protection against double jeopardy, which means you can't be tried for the same crime twice, the right against self-incrimination, which means you don't have to, it essentially means you have the right to remain silent, right? A right to not incriminate yourself. And then the right for eminent domain, if the government wants to seize private property, they have to compensate you for that. And so perhaps the most seminal 5th Amendment case is that of Miranda versus Arizona in 1966. So in this case, Ernesto Miranda was arrested and questioned by officers in connection to a kidnapping and rape case. After more than 2 hours of interrogation, police obtained a written confession. However, Miranda was never made aware of his constitutional right to legal counsel, which is in the 6th Amendment, or his right to remain silent, which is in the Fifth Amendment, a right to not incriminate himself. Thus, the written confession could not be used against Miranda in court. And that's why today, when individuals are arrested, they are read a Miranda warning, which informs them, the criminally accused, of their constitutional rights. Moving on, there are two major protections in the Sixth Amendment, the right to a speedy trial and the right to legal counsel. Gideon versus Wainwright in 1963 was a seminal Supreme Court case that would come to apply the protections of the Sixth Amendment to the states. And so for this case, Clarence Earl Gideon was charged in Florida State Court with felony breaking and entering. When he entered in court without a lawyer, Gideon requested that the court appoint one for him. And according to Florida state law, however, an attorney may only be appointed to defendants in death penalty cases. So the trial court did not appoint one. So Gideon represented himself, was found guilty, and sentenced to 5 years in prison. Gideon appealed his case all the way to the Supreme Court, where eventually the court ruled in a unanimous decision that state courts are required to appoint attorneys to defendants who cannot afford to retain their own legal counsel. Let's go to the Eighth Amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. And I want to focus on this cruel and unusual punishment because that's generally, when we're talking about the Eighth Amendment, that's the part that we're generally focused on. And how do we define this, right? How do we define cruel and unusual punishment? And generally, the death penalty comes up when discussing cruel and unusual punishment. And for a brief time in our nation's history, the death penalty was actually banned in all 50 states. That's a good exam question to see, that you'll probably see later. And the case that we're talking about here that was responsible for that was Furman v. Georgia in 1972. So Furman was burglarizing a private home when the resident discovered him. Furman attempted to flee and in doing so tripped and fell. The gun he was carrying went off and killed the resident of the home, and he was convicted of murder and sentenced to death. Furman appealed his sentence on the grounds that the death penalty was an excessive use of government force and that was cruel and unusual punishment, a violation of his Eighth Amendment rights. And so what's interesting here is that in a 5-4 decision, the court's opinion held that the imposition of the death penalty did in fact constitute cruel and unusual punishment, and it violated the Constitution. And after an extensive review of death penalty cases, the Supreme Court found that the death penalty was frequently applied in a manner that disproportionately harmed minorities and the poor. And so the court struck down all death penalty schemes across the 50 states until they addressed the following issues pertaining to the death penalty: that the punishment cannot be inflicted arbitrarily, the punishment cannot be degrading to human dignity, the punishment cannot be a mechanism rejected widely throughout society, and that the punishment cannot be patently unnecessary. Thus, the court's decision forced states to rethink their statutes for capital offenses to assure that the death penalty would not be administered in a capricious or discriminatory manner. And by 1976, just 4 short years later, most states had addressed the court's concerns and had re-implemented the death penalty. And lastly, thank you for bearing with me. I know there's so much content to talk about, but the last thing we're talking about is the Ninth Amendment. And here we talked about how this amendment here was particularly to assuage the enumeration trap concerns of the Federalists. And so what the Ninth Amendment states is that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. To speak plainly, what this means is that just because a particular right is not enumerated in the United States Constitution does not mean that it is not a right, and that instead the court should interpret these scenarios as rights of the people. And for the last 60 years or so, the Supreme Court has really come to interpret the protections of the Ninth Amendment to extend to, or to be understood as a inherent right to privacy. We have the Griswold versus Connecticut case in 1965, which was essentially a ban on birth control. And then the Supreme Court said, well, people have a reasonable, right to privacy. The government can't tell them that they, aren't allowed to have birth control. We have Roe versus Wade in 1973, which, as we all are probably familiar with, is, again, another key right to privacy case, that the government cannot tell a woman when she can and cannot have an abortion. And then we have the Obergefell versus Hodges case in 2015, which says people have a reasonable right to privacy. The government cannot tell them that they cannot engage in same-sex marriage. So all of these different rights, the right to access birth control, the right to an abortion, the right to same-sex marriage, the Supreme Court has understood and argued all of these to be constitutional civil liberties on the basis of what's written in the Ninth Amendment, an inherent right to privacy. However, recent decisions made by the Supreme Court have begun chipping away at the interpretation that the Ninth Amendment provides a right to privacy, most notably the 2022 decision in Dobbs versus Jackson Women's Health Organization, which, as you likely know, overturned the almost 50-year precedent set in Roe versus Wade, which granted women the right to an abortion. And in that case, Justice Alito argued that for a right to be protected by the United States Constitution, it must either be explicitly spelled out in the text or deeply rooted in our history and tradition. And in this opinion, Alito rejects the idea that the Ninth Amendment could be interpreted to protect a right to privacy against the government. And the reason that that's so concerning is because, like we just discussed on the previous slide, many freedoms that we know today, such as the right to birth control or the right to same-sex marriage, are all freedoms that the Supreme Court has argued are protected under the interpretation of a right to privacy under the Ninth Amendment. And this leads us to our very final stop and think of today's lecture. If the Ninth Amendment doesn't provide a right to privacy, then what does it protect? How would you interpret the Ninth Amendment? And recalling that basically all the Ninth Amendment says is that just because we did not enumerate a specific right in the Constitution doesn't mean that it is not a right. Take that into account. So take a moment to pause and reflect on your thoughts here. I'm so curious to see all the different ideas you guys have in the discussion boards this week. So take a moment, and when you're ready to proceed with the video, we're going to conclude with a summary of today's content. Okay, so here's a few bullet points of things that I want you to know for the first exam. First, civil liberties are individual protections from government restriction. We talked about how the Federalists were hesitant to include a Bill of Rights, chiefly because of this enumeration problem, and just look at all of the problems that's gotten us into with our discussion of the Ninth Amendment. Originally, the Bill of Rights did not apply to states. I want you to understand this selective incorporation process that's only made possible through the 14th Amendment. And I would like you to be able to articulate and recall the selective incorporation cases that we talked about that pertain to, extending the protections of freedom of speech, freedom of religion, due process, right to privacy to the state. So be aware of those cases that we discussed in this lecture. And then overall, I want you to remember that the Bill of Rights, it paints a picture of our core civil liberty protections, while the Supreme Court interpretation of those liberties continue to define the limits of those protections. These interpretations are constantly changing, and that's why it's so important for us to be involved in our government, to pay attention to the things that the Supreme Court does, to go out and vote, to hold our elected leaders accountable, because, they're the ones who write these laws that go to the Supreme Court, and we elect the officials who appoint the members to the courts and make all these decisions. So this is a constantly changing, evolving dynamic in our democracy. So I really hope you enjoyed today's content. That's all I have for you. As always, thank you so much for watching, and I will see you guys again in the next one.